This is ARC PDX.
Hello, everybody, and welcome to ARC PDX. I'm Wesley Ogle. We are on the road. We are right across the street from the ICE facility on Portland's South Waterfront. As you know, we go on the road at least once a week to dive deep into the biggest story. And this morning, we are tracking the key legal battles over the use of tear gas and other munitions at this ICE facility, as well as the city of Portland issuing a land use violation against the landlord of this building. Our show this morning is focused on the two key legal cases in federal court. They could impact how federal agents deploy tear gas and other munitions during protests at this facility. We're also taking a closer look at the other ways city leaders are trying to limit what they call unlawful practices by federal agents. That includes the land use violation issued against the ICE facility's landlord. So let's jump right into all of this. So one of the key cases that we are tracking this morning is the class action lawsuit filed by the ACLU on behalf of protesters and journalists who documented demonstrations here at the ICE facility. This lawsuit challenges how federal officers use tear gas against protesters. On Tuesday, Judge Michael Simon extended a temporary restraining order restricting how and when officers at the ICE facility can use tear gas and other crowd control munitions. The plaintiffs are now calling for a preliminary injunction, which will effectively extend that order until a trial. One of the key dates in this case is January 31st. Our crews captured the moment federal agents deployed tear gas into the crowd. In court documents, attorneys for the U.S. Department of Justice said before this happened, agents saw a group of 10 to 15 agitators banging on the guard shack on facility property. They then say agents issued 2 warnings with a long-ranged acoustic device before deploying the gas. But new testimony filed by Oregon Attorney General Dan Rayfield this week appears to dispute those claims. At least 5 witnesses said they did not remember any audible warning from federal officers before that gas was deployed. One of them, a registered nurse in Clackamas County, marched with her partner and her 2 kids, saying everybody in the crowd of thousands remained peaceful. An attorney for an Oregon labor union told the court that he was about 100 feet away from this building and the gas came without any audible warning. The next hearing for this ACLU case is set for March 2nd. Now, the other key legal battle that we're watching is the case filed by the people who live in the apartment complex right across the street from the ICE facility. I'm staring at it right now. It's right across the street from us. The residents of Gray's Landing and its property owners say that whenever federal agents deploy chemical munitions at protesters, they end up seeping into their apartments. Another plaintiff reports that she's been hit by stray rubber bullets, while walking home to her apartment. In a recent statement, DHS blamed, quote, rioters and the state and local authorities who failed to maintain law and order. And they say they're authorized to do what is appropriate and necessary. A federal judge could make a decision on whether to grant a preliminary injunction in this case as soon as today. And as we wait for that federal judge to make a ruling on the Gray's Landing case, ARC PDX's Daryl Burke sat down with ARC PDX reporter Dunphy, who was in the courtroom as the closing arguments played out. So here's their conversation, where Dunphy breaks down those arguments and how the judge responded.
I'm Daryl Burke here with our reporter Dunphy, who is also a lawyer. She was at the courthouse as those oral arguments played out in the Gray's Landing case. So, Dunphy, let's get right into it. Take us into some of the key arguments that plaintiffs have made and what are they sharing about their experience living there near the ICE building?
Absolutely, Daryl. So the plaintiffs are saying that when DHS deploys large amounts of chemical munitions like tear gas, it inevitably seeps into their property. As you probably know, Gray's Landing is located directly across the ICE facility, so it's not hard to imagine that that gas is directly flying into their properties, and they've provided video showing this, and they're saying that the impact of the gas is really bad on their health. Some are saying their pre-existing health conditions are getting worse. One woman testified, she says she has Cushing's disease, and it's actually worsening ever since protests started and confrontations with DHS started. Also, a domestic violence survivor testified, and she said her PTSD is getting worse because, as you'll see in the videos, or as you may have already seen, there's a lot of noise and there's a lot of sudden noise.
And how is DHS responding to this? Obviously, they're offering pushback here. So I know you heard from a spokesperson. How did they respond to this case, and what's their arguments?
So, Daryl, DHS has been very clear about this. They say this is their right to protect their agents or officers and their building. They're saying that they're constantly under threat by protesters. They've cited a list of examples in this latest case, including trespassers, including people throwing rocks at them. They said one time there was a mob on their property and they were making arrests, and one of the female protesters had a machete with her. So they were trying to basically paint a picture of how much their officers are at risk here and why they're deploying these chemical munitions. It's to get them off of the property.
And how was the judge reacting to all that? Obviously, that was a lot for the judge to take in. She's hearing arguments from both sides on this. How was sort of her reaction?
So she was asking a lot of questions of the defendants, and she could not square their logic. So breaking down the legalities, the plaintiffs are saying that their substantive due process rights are being violated. That, in simple terms, means the right to life, liberty, and property is being violated. One plaintiff even said she wears a gas mask inside of her home. So that's an example of their argument being made. So DHS was making their argument and saying that it's an inadvertent consequence of them doing something very necessary. But the judge could not square that logic because she couldn't understand whether it mattered if it's advertent or inadvertent. And for context, the plaintiffs aren't saying that DHS can't use these weapons. They're saying that DHS has to be more careful about how they're using them if they have to make sure it doesn't go into properties and to make sure it's not excessive and it's only used when there's what's called an imminent and concrete threat to human life.
And I know that the judge is going to have to work through a lot of those arguments here in trying to help her make a decision. Are you getting a sense of what ruling, like where that ruling could go? Or are you getting a sense of how she could make this ruling here?
So, Daryl, if I had to put money on it, I would say the judge is going to rule for the plaintiffs. And why I say that is because she had the most trouble reconciling their logic yesterday. So during closing arguments, the judge can ask questions about each side's theory of the case. And she had many questions about DHS's logic. She could not seemingly wrap her head around some of the cases they were using to justify their decisions. And she did not understand their point about the inadvertency of the impacts, because it seemed like the law that she was pointing out basically said it doesn't matter if it's inadvertent or advertent. The fact is the government is deploying munitions and it is harming unintended people. But what matters is that it's harming the people. That is what she was saying in her questioning. So that's why I would say she's likely going to go for the plaintiffs.
Gotcha. And obviously, you know, there's a connected case to this. They have some similarities, but there are key differences. We're obviously referring to the ACLU lawsuit against DHS here. So how could that particular ruling in this case and the Gray's Landing lawsuit impact the ACLU's lawsuit?
That's a good question, Daryl. And this is where things get confusing, and I don't mean to split hairs, but it's really quite simple, actually. The lawsuit brought by the ACLU is brought on behalf of protesters, and the lawsuit on behalf of Gray's Landing is brought on behalf of the residents that have nothing to do with the protest who are being inadvertently harmed. The ACLU lawsuit is about excessive force used on allegedly nonviolent protesters. They're saying DHS is using they're saying DHS is using way too much force on peaceful protesters, and I'm sure you all have seen the images, or if not, you'll see them. The evidence submitted shows officers gassing people who are standing still, who are sitting peacefully. There's a little girl who is marching with her parents who got some sort of gas in her eyes. You can see that image actually went pretty viral of her having to wash her eyes out, and she was crying. So those are the kinds of incidents the ACLU is putting forward. So totally different from Gray's Landing. Gray's Landing, people just want to live in their homes without having to deal with chaos.
Yeah, thanks for clearing up any kind of confusion that could have caused. Obviously, these cases, putting them next to each other can sort of muddy the water, so thanks for that clarity.
Absolutely.
Dunphy Varma here, our ARC PDX reporter and lawyer, breaking it down for us. Thank you, Dunphy.
Of course, Daryl. Thank you for having me.
Hello and welcome everybody to ARC PDX. I am Wesley Ogle and we are on the road this morning right across the street from the ICE facility on Portland South Waterfront. You can see it right behind me. We go on the road once a week to dive deep into the biggest story. So this morning we're tracking the key legal battles over the use of tear gas and other munitions here at the ICE facility, as well as the city of Portland issuing a land use violation against the landlord of this building. This morning, I'm talking with legal experts to help break down the key arguments in these legal battles and to see how they could play out in the coming days, weeks, and months. So joining us live now on Zoom is Garrett Epps, a professor of practice at the University of Oregon School of Law. He is also a longtime contributor to The Atlantic and legal affairs editor at the Washington Monthly. Professor Epps, thank you so much for joining us on ARC PDX this morning.
Hey, great to be here, and thank you for being where you are.
Thank you. Okay, I want to start with the Gray's Landing case, the one on behalf of the residents at the apartment complex here, because we could get a decision from a judge on that today. From the arguments that you've heard from both sides, can you maybe guess how you think the judge is going to rule in this?
Well, you know, predicting federal judges is usually a losing game, but I will say that the judge in this case has shown a certain amount of impatience with the government. The government across the board in these lawsuits against ICE actions, the government has shown a tendency to drag its feet and sometimes even to mislead the court. So judges get out of temper with them. It's an interesting, novel claim. It's not a claim by people who are protesters that they've been gassed. It's a claim by the people who live right there that gas is being used in ways that are destructive to them. And then beyond that, there's a argument lurking that their gas is being used as part of a performance, as part of the administration wanting to show how tough it is and wanting to have TV footage and so forth. The interesting argument is there a federal cause of action? Can you actually sue for so-called incidental use of tear gas? And the argument that came up in the case that is really interesting is that this is a case like the case in Flint, Michigan, in which action by the government put lead into the drinking water, and the drinking water was drunk by citizens of Flint and by children who suffered damage. And the court said this is an offense against your bodily integrity. The government has said there's no such thing, you know, that there really is no such cause of action. And beyond that, you know, they've gone and argued that there's no what they call standing on the part of the plaintiffs, that, you know, okay, you've gotten gassed a couple of times, big deal. You know, there's no proof it's going to happen again. You really don't even belong in court. This case ought to be thrown out. Doesn't strike me as a very strong argument, but that's where the government is at.
Okay, let's move on to the ACLU case now, because a federal judge just extended the temporary restraining order on Tuesday. The plaintiffs are now calling for a preliminary injunction. So what would that preliminary injunction do?
Well, it's a very interesting order. This is I call it the Portland Frog case because the frog is one of the plaintiffs. But it basically contains allegations in the record, which the judge seems to, that the ICE and other federal officers are using gas and so-called less lethal weapons like pepper balls for purposes of punishing or discouraging legal protest. And the judge has issued a very carefully narrow temporary restraining order saying not that you can't use these weapons, but you can only, he says the government can only use the weapons to avoid grievous bodily harm. And beyond that, that they can't aim at protesters' heads or faces, which they have done, unless they are threatened with death. Only in a case where deadly force would be authorized by law. So it's a pretty strong rebuke. And if you read the TRO decision, the the judge plainly does not believe the assurances he is being given by ICE. He thinks that ICE is using this gas for propaganda purposes, and they're using it against people who have every right to be present and demonstrate and show their disapproval of government actions, which is what the First Amendment protects.
So these two cases are obviously very similar, but separate cases. Yeah. Can a ruling in one impact the other? Like, how do these play side by side at the same time?
Well, they're not precisely the same issue, but they do have the same underlying factual allegations, which is in effect that ICE is using these munitions when they're not needed, when the Department of Homeland Security's own use of force policies, which have been made part of the record, which you can review online. That their own policies indicate that these munitions should not be used in this kind of situation. So you have a situation where the government agency is behaving, in my opinion, fairly lawlessly, and is almost daring the court to do something about it. And the use the same issue underlies the Gray's Landing case, which is you're gassing people. The people are suffering serious health effects when you use gas for the TV cameras, or as something aimed at the audience of one in the White House to show him that DHS is being tough and so forth. So the two lawsuits make very different legal claims. One says bodily autonomy, that's the Gray's Landing case, and the other says use of force, Fourth Amendment and Fifth Amendment, and First Amendment. But they're both dealing with the same set of operative facts, and the government is dealing with the fact that increasingly in courts across the country, ICE and the government representing these federal agents has very little credibility. They have misrepresented the facts to multiple courts, and the judges are losing their patience. There was an opinion in California by Judge Sunshine Sykes, in which she basically, this is about detention of immigrants, and she basically just said the government comes in here and lies and lies. So, I think keep your eye on both. They're both liable to come out the same way, but that's worth every penny you just paid me for it.
All right, I want to move on to the land use issues that are going on here, because last Friday, the city of Portland upheld the land use violations here at the ICE facility. The property owner now of this facility has until March 16th to either fix the violations, or they then have to pay a almost $1,000 monthly fee. They can also appeal this decision. They have a few more days to do that. Can you possibly guess what you think this property owner would do of those three options that they have?
Well, my guess is that they'll run out the appeals process if it doesn't subject them to, increased liability. I don't see any reason why they wouldn't. That would give them more time to prepare. It does seem likely that the appeals process is going to produce a finding against the landlord. We all know what ICE has done. You can see the boards, behind you there, and they have promised not to do that, and they've promised not to detain people more than 12 hours. ICE doesn't follow anybody's rules. And in this case, the landlord is catching the flack because the city has no authority to order ICE to do anything. But this building is owned by a property owner who is governed by city land use laws and can be subject to fines. Now, like a federal judge, they can't just sort of say, we've had it with you, we're right away. It has to follow a fairly elephantine process, step by step by step, because it concerns the property rights of a private citizen.
And just, broader picture here, how are you seeing, all of these things, these cases and the land use violation all playing out? Like, how long do you think we're going to be talking about this? Is this going to be going on weeks, months? Could we be talking about this for years ahead?
Well, in a sense, you're asking me what Donald Trump and Kristi Noem are going to do, and you know they don't know. How am I going to know? But I think the question is whether the administration wants of scenes in Portland. The president is fixated on the idea that Portland is this war zone, this hellscape, which every other person who has been there knows it is not. And we know there were plans during Operation Metro Surge in Minneapolis. There were plans being drawn up to do a similar kind of surge in Portland. I think, you know, one begins to pick up signs from inside the administration that they are backing off from this. They've realized that the visuals aren't good. They've realized that the two fatal shootings in Minneapolis have caused a lot of problems for the administration and their policies. So I think it's possible they're just going to say, walk away from Portland. I mean, Portland deployed one of the most amazing protest strategies in American history: frogs, salsa dancing, yoga classes, naked bicycle rides. You know, they very creatively made fools out of the people in the ICE facility, and they may just not want to take that on anymore. But again, my prediction's worth every penny you pay for it.
Well, Garrett Epps, professor of law at University of Oregon, really appreciate your time and your expertise and your analysis this morning. Thank you so much for joining us.
Enjoyed it. Thank you.
Hello, everybody, and welcome to ARC PDX. I'm Wesley Ogle, and we are on the road right across the street from the ICE facility here on Portland's South Waterfront. As you may already know, we go on the road once a week to dive deep into the biggest story. And this morning, we are tracking the key legal battles over the use of tear gas and other munitions here at this ICE facility, as well as the city of Portland issuing a land use violation against the landlord of this building. So our show this morning is focused on the two key legal cases in federal court right now. They could impact how federal agents deploy tear gas and other munitions during protests here at this facility. We're also taking a closer look at the other ways city leaders are trying to limit what they call unlawful practices by federal agents. That includes the land use violation issued against the ICE facility's landlord. One of the cases is the class action lawsuit filed by the ACLU on behalf of protesters and journalists. The other was filed by the people who live in the Grays Landing apartment complex right across the street from the ICE facility. The plaintiffs for both cases are seeking a preliminary injunction limiting the use of tear gas near the facility, but the cases also do have some big differences. So joining us now to talk about the legal battles is Tung, a law professor at Lewis and Clark College. Tung, thank you so much for joining us on ARC PDX.
Yeah, good morning.
Good morning. Okay, I want to start with the Grays Landing case on behalf of the residents here at this apartment complex, because we could get a decision from the federal judge on that today. So from the arguments that you've heard from both sides, can you guess how you think the judge is going to rule in this?
My guesses are really bad, but I think this case is interesting because the residents, I don't want to say they're more deserving of relief, because obviously if there's a violation, then whoever has been suffering the violation should win the case. But I think in what you might say the optics of it, the residents aren't doing anything. They just want to be left alone. And then there's all the stuff that's happening. So I think that, could add a little bit of weight to their claim.
Yeah, I was actually going to ask you that question of how the plaintiffs make this very different. But I want to talk about now the ACLU case, because of course the plaintiffs in that are protesters and journalists, and they're calling for a preliminary injunction. What would that do if they got that preliminary injunction?
Yeah, so that case, we have a little bit of a better idea because Judge Simon has already granted a TRO in that case. And so the difference between the TRO and a preliminary injunction is just basically duration. The TRO is meant to be just no more than 10 days or 14 days initially. And the idea is that something should be held in the status quo, the way things are right now, so that the lawyers can have time to file their motions for the next step, which would be a preliminary injunction. So the judge in that case is basically saying that, well, based on what I've seen right now, I'm not deciding the case totally, but based on what I've seen, I think there's enough to say we should freeze things and in this case, issue guidelines on when ICE can and cannot use the tear gas. Now, that only lasts for a short period, which is enough time to get to the next step, which is coming up soon in Judge Simon's case. So the preliminary injunction would then last longer for the duration of the litigation until the judge can reach a final decision. So it's basically the same process that we saw play out in Judge Immergut's court last fall with regard to the troop deployment litigation.
So, these two cases are playing out side by side at the same time, and they're really similar, but there's also some really big differences between them. Could the way, one federal judge rule impact how another one rules, or what happens with these cases, or are they just completely separate?
They're separate in the sense that what one judge does is not binding on another judge, but they're also obviously related because it's very similar legal issues. And so what one judge does may give a roadmap for the other judge, or one judge might say, hey, the other judges are ruled on these same issues, and I think how they came out is very persuasive. So I'm just going to adopt the same reasoning. And then also, just because ICE is the same defendant in each matter, what one judge does could actually affect what ICE is able to do, and that would necessarily have an impact in the other case. So, for example, in this case, the residents' lawsuit, they went straight to the preliminary injunction request. They did not seek a TRO, and that's, I think, because Judge Simon in the other case had already issued a TRO that was in effect. And so it would be duplicative to seek another TRO unless you were trying to get one with different terms.
Wow, yeah, that was really interesting. I'm glad I asked you that question because I've been very curious about how they could impact each other. I want to now move to the land use violations here at the ICE facility because just last Friday, the city of Portland upheld their land use violations here at the facility. So the property owner of this facility now has till March 16th to fix these violations or face an almost $1,000 monthly fee. They can also appeal to the city hearings office. They have like a couple more days to be able to do that. So out of these three options that the property owner could do right now, can you guess what you think they're gonna do?
I would guess maybe appeal, but a lot of this just depends on how much the federal government, I guess, is going to back up the landlord. This is an interesting question. The land use matters themselves are not my expertise, so I couldn't really speak to that. But the question about can the city use its municipal powers to essentially try to force the federal government to do or to stop doing something is, I think, a very interesting related question. And the way I was thinking about this is, let's say that there wasn't a landlord involved, that it's just simply a federal building that is owned by the federal government, like the courthouse or the federal building downtown. And the city tried to use municipal powers to, basically impose a fine if they stopped doing something or if they did not stop doing some activity. That, I think, would run into a very serious problem with the supremacy clause for the city to basically single out a federal building for some kind of required behavior. So if that's true, is it different if it's a leased building instead of one that's owned by the government? And that gets into property law issues that I'm not sure about, but I think that's the parameters of what the debate would be. Can the city essentially force through local law the federal government to act in a certain way? And if the answer is no, and that the being a tenant as opposed to an owner makes no difference, then maybe the landlord just lets the federal government and the city battle it out.
Yeah, you may not be able to answer this one too, but I am curious about the relationship between the property owner and the federal government. Like, let's say the property owner agrees with the city, they feel the same way. Do they have any power? Could they just, revoke the permit for ICE to be here at their property?
That would depend on what essentially the rental contract is. Maybe it says that either side can terminate the lease with, I don't know, 30 days notice, or no notice at all, or maybe it says that conditions have to be met for the lease to be terminated. I don't know. I mean, just a very weird example would be the naval base we have on Guantanamo Bay, Cuba. That lease requires both sides to agree to terminate it. So that's why we've held on to it all these years, even though Cuba, of course, I think would love to get rid of us, but they can't unless we agree to terminate the lease.
Oh, yeah. Wow. Interesting. Okay. So broader picture here, when we're thinking about these three, battles playing out here with the ICE facility right now, when and how, could this all be decided? Am I going to be out here next year or the year after? Is this going to play out over the next few weeks, months, or a years-long situation here?
Normally, litigation can take a long time. But I guess the good news for you is that Judge Immergut demonstrated that on some of these matters that actually the timeline can be shortened quite a bit. Because I think from start to finish, I don't think that case lasted more than 6 weeks, maybe 2 months, but somewhere around there, which is really, really fast from start to complete finish. So, it depends on how much testimony and evidence has to be generated, and essentially, how much the judge is willing just to put everything aside to crank on one particular case. But like I said, she demonstrated that you can actually get this kind of litigation done fairly quickly.
Okay. All right. Tung Yin, law professor at Lewis and Clark College. We always appreciate your time and your expertise. Thank you so much for coming on this morning.
Yeah, of course.
Welcome back, everybody, to ARC PDX. We are on the road outside Portland's ICE facility. And as we mentioned at the top of our show, we are tracking what the city of Portland is doing in response to what is happening here outside the ICE facility. And that includes the city's decision last week to uphold its land use violation at the facility. The property owner now has until March 16th to either correct the violations or face a $934 monthly fee. They also have a few days left to appeal this decision. This decision follows an administrative review of the violation requested by the property owner. That review found ICE is out of compliance with land use conditions that were agreed on more than a decade ago. That includes at least 25 instances of people being detained and held beyond the maximum 12-hour limit between October 2024 and July 2025, as well as federal agents boarding up ground floor windows, blocking anybody from seeing inside. Again, the property owner is on the hook for the fines, not ICE or DHS. If the violations continue beyond 3 months, those fees are going to double. Now, the property owner can appeal to the city hearings office within 10 business days before starting to pay that fine. But city officials have confirmed that they have not received an appeal as of yesterday afternoon. We have reached out to the property owner, but they have not yet responded. Welcome back, everybody, to ARC PDX. We are on the road tracking how Portland city leaders plan to apply recently passed ordinances related to the ICE facility here in Portland's South Waterfront. Part of a new city ordinance allows fines to be issued over nuisances at detention facilities. That includes the use of chemical munitions. The ordinance, which was passed in December, doesn't actually list Portland's ICE facilities specifically. It was created to offset police overtime costs and environmental problems related to large-scale protests at detention sites. It also created a process for reporting nuisances outside federal detention centers. Earlier this month, we talked with City Councilor Angelita Murillo, who was one of the co-sponsors of this ordinance. She says it's now in the hands of Mayor Wilson's office to finalize an enforcement process.
We were hoping that the executive side was going to take the time to really make sure that it was ready to go once the ordinance passed, but they are in the rulemaking process. So the executive branch, the mayor's team, the deputy city administrators, we need them to start the rulemaking process urgently and to have that ready to go so that the fines can be put in place, because this should have been done a long time ago. We as counselors, me and Councilor Green, sent out a letter to Mayor Wilson. We publicly posted it asking the executive branch to move with urgency on this issue, because we know it's a matter of public urgency, and he has been publicly responsive to that now. It sounds like they are ready to move on that and make sure that that happens. But we also have existing nuisance code that does not need rulemaking, that already exists, and we expect that the executive will use all of the powers that they have under that nuisance code to enforce the laws. I will also say my office has been working in coordination with the county. They, as the public health agency, are very interested in doing air quality monitoring near the McAdam ICE facility, and they have monitors that are ready to go. My office connected the executive branch with those folks at the county that were interested in doing that, and we have not seen movement on that. So we are hoping that the events of this weekend, despite how terrible they were, will result in something positive, which is more urgency from the executive to actually get moving on some of these issues.
Now, in a statement to our newsroom, the mayor's office said the city leadership is committed to safety and accountability, adding, quote, executive leadership is actively coordinating and moving quickly to finalize an enforcement process supported by comprehensive legal review. Now, we have previously talked with City Councilor Mitch Green, the other co-sponsor of this ordinance. Here is how he explained his goals with this ordinance when it was being discussed late last year. Take a listen.
The basic idea is that there are some types of facilities or land uses that have a very specialized role, but have an outsized impact on the community. And detention facilities are one of those types of land uses. And so based upon the indirect or sort of unintended consequences of their operation in the city, taxpayers experience significant costs associated with those uses. And so the idea here is to step in and say, well, the city has an obligation to recover for the public the costs of a very specific land use, and that's what this does. So if this passes, my understanding is it would apply to anybody who would then engage in the leasing of that type of activity. And so it's not a by incident, it's not like you get charged per protest, for instance, but more rather the presence of this facility itself raises a material cost and you'll be charged a proactive fee. There are also the costs that other third parties are incurring just from the public as a presence of the ICE facility in particular. There was a school, a charter school, that had to move because of chemical weapons being used in response to people exercising their First Amendment rights. And that's a cost that's currently not recoverable. And so the idea here is that detention facility fee could provide a revenue source to make our community whole.
We will, of course, keep you updated on the final plan from the mayor's office. About 40 people packed council chambers on Wednesday, disrupting the city council meeting. They demanded that the city revoke ICE's permit to operate out of the facility here. 4 people were actually arrested on various charges, mostly trespassing and disorderly conduct. Chief Bob Day denounced what he calls violent threats during the protest. He says the threats were so serious, nearly every available officer in the city was called to respond. We talked with one of the protesters who says the protesters were just holding up a piece of paper showing them how many signatures a petition had.
There was a demonstration of intent last night that we hadn't seen, where somebody actually attempted to or was successful getting over the dais, which is unique. That is a raised level of concern.
Could you see where police might be coming from when they say they see someone walking past the dais and approaching councilors?
I don't see that at all, because quite frankly, Portland Police Bureau does nothing when ICE assaults people in Portland all the time. No one was threatening the council. No one was being aggressive. It was a completely disproportionate response.
What do you say to protesters who think the response was excessive and disproportionate to the situation?
Yeah, well, actually, that number of officers, I would like to have seen exponentially higher. The importance as we continue to emphasize the need to have a fully resourced, fully staffed police department to meet the emerging trends and challenges that we're facing as a major city are not going away.
At least 26 police officers were ultimately called out to City Hall to clear the council chambers and lobby. No injuries were reported. And although he was not able to join us live on our show this morning, earlier this week we talked with Portland City Council President Jamie Dunphy. We asked him about his response to the calls from advocates to completely revoke the ICE facilities permit. So here's part of that conversation.
There's pressure on the city right now to revoke the South Portland ICE facilities land use permit. There's been a lot of confusion about that process and where the city stands. Can you provide some clarity on that?
Yeah, so this is a administrative legal process. Very recently, I think this week, the city did again affirm that they are in fact in violation of their land use permit. They are in fact, according to the administration, detaining people on site for longer than they are allowed to do. The landlord has legal rights. They have an ability to appeal these decisions, and we have to go through these processes. I know that there are folks in our community that simply want the city to come down and shut that facility down, but that is not something that we're going to be able to do right now. But we are taking it very seriously to try and limit the way that the feds are impacting neighbors, the way that they are using chemical munitions, and the way that they are truly just kidnapping neighbors off the streets. We are doing everything in our power to try and stop and slow that process. But ultimately, the city of Portland is not going to be in some sort of armed conflict with the federal government. We have to use the tools that we have, and we can't break the law in order to compensate for a federal government that simply doesn't care about our laws.
What do you say to the protesters who are asking for sanctions on the ICE building? They're saying the process is taking too long.
I completely understand their passion. I completely understand their want to see something happen in our community and the need to feel some level of control against tyranny, against a federal government that does not care about our neighbors, that does not care about our standard of living or the way that we choose to live here in Portland. I totally understand that, but we have to follow the rules. We cannot meet illegal actions with illegal actions. We have the tools that we have before us, and these processes are slow. But they're deliberate, they're intentional, and they have to be that way, because otherwise, I don't really know what we're fighting for.
Some people say we're fighting for an ICE facility here in Portland. There are people on the other end who say we need this facility. What do you say to them?
You know, I've talked to a lot of immigrant and refugee rights groups, the ACLU of Portland, Portland Immigrant Rights Center, these folks who are actually working with immigrant and refugee families, and they say that thousands of people go to this ICE facility every day in order to keep up with their paperwork, to make sure that their process for getting citizenship or legal status is in accordance with the law. And we understand that often people who go into that facility for basic paperwork aren't coming out on the other side. But if we don't have that facility in Portland, we're going to be shipping people to Eugene or Tacoma, where we can't get our legal services, where we can't get our community involved, and we can't get them the resources that they need. So unfortunately, that does play a really important role. And I've heard very loudly from the people who are actually doing the work with these communities that this facility, it plays a vital role.
So that's the difference to a lot of people, is that this facility does a good job. It helps people. But outside of the facility, there are things going on that they don't like.
You know, even within inside the facility, we see that ICE and federal law enforcement are doing a lot of bad things. But this is simply the facility where the administrative work happens, and we don't have another option right now. I absolutely understand that we don't want to see these jackbooted thugs in our community who are using chemical munitions against peaceful protesters. That is not what we're trying to defend. But within the realm of legal immigration services, this building plays a vital role. And I understand why protesters want to see this building gone. But for the thousands of families who live in this community, including thousands of families in my district of East Portland, they want to be here and they want to play the game. They want to do it according to the rules, and that means they have to show up to their appointments. And if they don't show up to their appointments, they are putting themselves at serious risk.
Well, what are your priorities then? What are the options? Do we move the ICE facility somewhere else and the same thing just happens there?
I mean, almost certainly. The ICE is the most well-funded federal police force in the world. They dwarf what the city of Portland's budget is for the ability to do law enforcement. We're not going to be in direct conflict with ICE in any sort of meaningful way. We're not starting a civil war. But we cannot tolerate the kind of violence that we are seeing from our civil servants. These are civil servants who are working for us, and we understand that they're coming from a federal government that does not care about us locally and wants to inflict punishment and create spectacle on TV. But gosh, Portlanders have been showing up in the exact right way against this. We're not meeting violence with violence. We're meeting it with absurdity. We're meeting it with Portland values. And I'm so proud of the way the city has responded to try and just throw sand in the gears of this administration.
Welcome back, everybody. We are wrapping up our time on the road here, diving into the latest updates on key legal battles over the ICE facility here on Portland's South Waterfront. We brought on legal experts to help us break down the newest developments in court and their possible implications. We also took a look at the land use violation case as well. So if you would like to see the full deep dive again, or you want to share it with your friends and family, just point your phone's camera at the QR code on your screen, and that will take you right to the ARC PDX YouTube page, where you will be able to see the show in full. Thank you all so much for joining us this morning. Don't forget, we go on the road almost every week, so please let us know what topics we should tackle next. Until then, have a great rest of your day and a wonderful weekend, and stay safe out there.